right, everyone. Good afternoon. It's so great to see you here. You know, each year we're privileged to welcome a prominent jurist to the College of Law for a deep dive into our way of life here as judge in residence. And thanks to the leadership of Professor Mariana Bettman, the judge in residence visit has become really one of the highlights of our year, every year. She, as you know, is someone who's going to keep our visitors very busy, hopping with a heavy schedule of classes and gatherings that's designed to take advantage of this wonderful visit and allow students and faculty to engage with the judge and allow the judge as well to engage with as many people as possible and have the opportunity to spend time casually and in a relaxed fashion as well. So it turns out to be a really stimulating and invigorating 3 days for all of us. You know also that she's a stickler, Judge Bettman is, right? Yeah, she is. And she settles really for nothing short of the very best, and that includes not only your performance in class and on final examinations, but also in everything that goes into her choices to whom to extend this important invitation every year. And so each year we are visited by some of the very finest judges you're going to find in the United States of America, and that's certainly the case this year with our wonderful guest, Judge Solomon Oliver Jr., who is the Chief Judge of the Northern District of Ohio Federal District Court. He's been in that position since 2010, but a lot longer on the court itself since the mid-90s. As a federal judge, you know he hears a wide range of cases, all important, all well decided. And let me tell you a little bit about him, because it's really important that you appreciate, I think, the journey that has brought this fine man to your room today. He's a 1969 honors graduate from the College of Worcester. He went on to receive his J.D. from New York University School of Law in 1972, took a master's degree in political science from Case Western, and began as an assistant professor of political science at the College of Worcester before serving as a law clerk to the late, great, and I mean great, Judge William Hastie of the U.S. Third Circuit Court of Appeals. From 1976 to 1982, our judge was an assistant U.S. attorney in Cleveland and also served as the chief of that office's civil section for 4 years. In 1982, he became chief of appellate litigation in the U.S. Attorney's Office before deciding that our way of life here in law schools was even better, and joined the faculty at Cleveland Marshall College of Law. He, from 1991 until his appointment to the federal bench, he also served as the Associate Dean of Faculty and Administration at Cleveland Marshall School of Law. He's a member of the American Law Institute, the American Bar Foundation, the Board of Trustees of the College of Worcester. Our judge has previously served as a member of the Judicial Conference of the United States, which is the policymaking body for the federal judiciary, and currently serves on its advisory committee on civil rules. This is what I'm about to say may be of particular importance to a lot of people in the room. For several years, the judge has served on the council of the ABA section of legal education and admissions to the bar. That's the group that actually regulates and the accreditation of all American accredited law schools. And true to this phrase that no good deed goes unpunished, they turned to him again to serve as chair of that council at a very critical time when the reform of the accreditation standards for law schools was coming to a head, and indeed he brought it to an admirable landing with great leadership. Please recognize, though, that the road that brings Judge Oliver to us is one that was not easily traveled. He's the fourth of 10 children of the Reverend Solomon and Willie Lee Oliver. He grew up in a small town near Birmingham, Alabama, during a time of segregation, repression, unrest. He attended segregated and public schools, and in 1963, the year of the Birmingham church bombing, Judge Oliver was attacked by a white gas station attendant when he tried to use the restroom. The attendant apparently was convinced that the judge and his two companions, who were church deacons, were there to help integrate the facility, but in fact they were traveling through rural Georgia on their way to a church convention. Because of the sometimes harsh lessons and certainly enduring lessons that Judge Oliver has learned throughout his life, he demands that his courtroom be a place of respect. Respect for the people who come before him. The attorneys are expected that they shall respect each other, and everyone shall respect the law as well. For leaders like Judge Oliver, inspirational leadership is its own reward, but others have rightfully chosen to acknowledge his accomplishments. He's received distinguished alumni awards from not one but two of his alma maters. He's also received an honorary Doctor of Laws degree from both the University of Akron and the New England School of Law in Boston. Now, since yesterday, he's done us the great honor of allowing us to honor him as our judge in residence. He's been very, very, very busy. Many of you have probably already enjoyed his presence in one of the classes. I counted yesterday at least 4, probably a few more this morning. I think every first-year student is going to have the opportunity to be with him. He's also broken bread with folks. He's gathered with some of you on a casual basis and done really all and then some of what we expect of a great judge in residence. He's here now to deliver a talk that is awfully interestingly titled, Thank God for Life Tenure. But I'm going to ask you to put your hands together and give him the warmest welcome.
Thanks, Dean, and thank you all for being here. I was coming down the hall with Judge Professor Bettman, and we saw a lot of students, a lot of people coming in, and we said, oh, it's pizza. I'm smart enough to know that pizza trumps all. It's good to have you all here. To all of you, I'm just delighted to be here at the University of Cincinnati College of Law. I've had a wonderful time already. I was in 4 classes yesterday. I've had 2 this morning. I've enjoyed each and every one. Judge Bettman is a tough taskmaster. I still got some more this afternoon, and then I think I go to about 11 o'clock tomorrow visiting classes. You do a wonderful thing in having this kind of program. Not very many schools have jurist in residence programs. I know there are lots of things that happen in law school. Lots of scholars coming through, lawyers coming to judge moot court, judges coming through. But the idea of having a lawyer or a judge come through and spend 2 or 3 days interacting with faculty and staff and students, exchanging ideas, that's really what legal education should be all about. And so I think you're setting an example for other law schools, and I think other law schools are starting to adopt and will continue to adopt this model. It's just a wonderful way to have an exchange where theory can meet practice and practice can meet theory. Now, Dean, when I chose this title, I knew there are a lot of law professors who would be here. And I was chair of the section of legal education, admissions to the bar, as the dean said, last year. And we went through the process of looking at the standards that should apply to law schools. And one of them was whether or not there should be a continuous requirement of tenure for law professors. And there were various models in terms of how you could secure academic freedom and maybe some security position without it. In the final analysis, professors still have tenure. We did not change the standard, but I think we went through a very good introspective process in regard to looking at that issue. We know there's good to the process, and we also know we had much criticism about how, in particular cases, it could be abused. And so I thought it would pique your curiosity to talk about tenure. And as a judge who's tenured, I thought an appropriate title would be Thank God. Thank God for life tenure. As most of you know, I'm the current chief judge of our court, and I've been on our court for almost 20 years. So long that people are now starting to ask, how long are you going to go? Or sometimes, how long you think you will go? Oh, I heard you were stepping down. I heard that a few times recently. Now, this probably sounds familiar to some of the more senior members of the faculty here at the law school, but I'm not going quite yet. But let me just say, as much as I enjoy my job, helping people and institutions and resolve some of the most important matters and issues in their lives, it is good to get away sometimes and to have an opportunity like this. Now, the dean said I served as chair of the section of legal education admissions to the bar last year, and I'm immediate past chair this year. And I continue to serve, but I, of course, don't have the same responsibilities that I did last year. But the recent efforts of the council have been to look at standards which would require law schools, or at least put law schools in a position to require students to look at all aspects of the practice and to do it in a holistic way. And that means that in regard to the doctrine that you normally teach, that's great. We've always done that. We know years ago we went to law school, it was how to think like a lawyer. And that is critically important. How to write like a lawyer is critically important also. But the other thing that's important is to understand how lawyers work and act in real practice. And it's important you get some exposure to that while you're here. And the third aspect is the ethical part of practice. What does it mean to be a professional, a professional, and to serve as a lawyer and understand your obligations to the client, understand your obligations to the court, and understand that you are more than just a zealous advocate, that you have a role as a counselor, as an advisor, and you have certain rules that require you to be candid with the court, for example. And so all of those kinds of things, we hope that when you get to the end of your education, that those things have been integrated in a way that you can see the lawyer as a whole. You'll never be really ready when you come out of law school to practice. No one ever is. The idea is to be more practice ready for a lot of reasons. One, because it's good training, but because the way the legal market is going, it's becoming more and more important that you have the kind of preparation here that will allow you to get a good start when you come out. And so that's what I've been involving myself in the last 2 years with section of legal education, admissions to the bar, is looking at the standards, is trying to figure out what is it that would be reasonable to require law schools to do. And there are a lot of other things that law schools do that they're not required to do, and we're not trying to micromanage that. Pro bono activities and those kinds of things are certainly important, both in terms of service component, but also in terms of learning how to be a lawyer. Now, so this program, the program that you have here, the Jurist in Residence program, contributes to this goal. And it's my honor to have been chosen this year's Jurist in Residence and to follow the very distinguished group of judges that you've had in the past. So again, Professor Bettman, thank you. Dean, thank you very much. Now, let me just say that I have a few disclaimers to start. First, professors, this is not meant to be an empirical work or discussion about the tenure of life judges, or even a philosophic justification of the highest order. I will simply share with you some of my thoughts, ideas, and reflections on why I think the founders were spot on in their decision to provide life tenure for federal judges. This will be based in part on my experience, on anecdotal examples from history, and only partially, but a little bit based on my experience when I went to Tanzania in 1995 and spoke to a group of East African judges. I will share with you up front that if I was not a federal judge, I would not be a judge at all. I would not have had the stomach for being a judge who would run every 6 years for office. Now, I do have high respect, high regard for the judges in the state system who have tremendous caseloads, who are dealing with some of the most important issues in people's lives. But it's not a job that I could accept. It's not one that I could pursue. It's not one that I could do. So I'll tell you that up front. I come in with that orientation and that bias. So you say my mind is made up already. I have tenure, right? And I said I wouldn't take the other kind of job. But I think nevertheless that there were sound reasons for what the founders decided in regard to life tenure. They made some mistakes, the founders, and I'm looking at Dean Joe Temain, 19.
That wasn't my mistake.
Not that one. We served together in a National Endowment for Humanities seminar at Stanford. It was 1987.
Yep.
It's been quite a long time. And it was during the bicentennial of the Constitution. And so when I mentioned that the founders did make some mistakes, I was reflecting on the fact that we studied some of those mistakes that they made and their effects on history over time. When you start with looking at the federal judiciary, you start with the Federalist Papers, and you know that that was a tract of 85 or so essays and articles by John Jay and Madison and Hamilton in support of the Constitution being adopted. And we don't go through all 85 of those today, don't worry. And we won't spend time much on any of them, but Federalist 78 is where you would start if you're looking at the historical origins of federal judiciary and the understanding of why life tenure was suggested. And it's all grounded in the concept of separation of powers, you know that, and also grounded in the concept that of judicial review. I think you've all covered that now in constitutional law. And it sounds elementary to us now, the concept of judicial review, but it was not so elementary then. And believe me, it was not so elementary when I discussed with East African judges in 1995 the concept of judicial review. I'm talking about Tanzania and Kenya and the Seychelles and Uganda. The concept that a judge could actually say that what the executive had done was unconstitutional and strike it down, or say whatever the legislature had done and strike it down. Those were concepts that they were working on. They were not yet there. The culture was not there. And so in our history, the concept of judicial review was not thoroughly accepted. There was some concept that, you read the Constitution, the legislature can read it, and the executive branch can read it, and the court should just simply be, decision makers in regard to disputes, but not to actually interpret what they mean. And so it was an important concept, important understanding. And so the founders decided that if judges were going to have the kind of role that was envisioned, where they could look at the acts of the other branches and determine whether they measured up to the Constitution, that then they would need some independence. And so therefore, rather than have them elected, they would have them appointed. Also, the concern was about if there were to be elected judges, then judges might be elected based on how people felt at the time. And yet, the Constitution's values were enduring values that were to endure forever, and they were to stand regardless of what the public opinion was, the populace at a given time. And so the idea is that the Constitution should not change, the primary values of the Constitution, rights under the Constitution should not change because people at a particular time were not in support of them. We've seen, for example, surveys over time where we talk about communism in years gone by, and the question was whether a person should have a right to assert their ideas and so forth. In different periods of time, there would be very little support for that kind of thing in other kinds of areas. And yet, when you look at the First Amendment and you analyze it the way it should be analyzed, one would conclude that even if it's an idea that one does not support, the person would have the right to assert that idea anyway. And so it was all of the things you know and you understand in regard to why they thought it was important to have persons who would not have to depend on being elected and by the populace in that regard, and that they should have life tenure, and that was a big step. I mean, there are a few states that were moving toward that, but life tenure was a big one, and there were certain concerns about that in any setting when a person has life tenure. There's a certain arrogance that a person might have. There's a sense that the person may not be accountable at a certain period of time. There are all those kinds of concerns. But they decided that despite those concerns, that this was the way to go. And so they looked at, as Hamilton said in the 78th Federalist, they looked at the court, the judiciary, as the guardians. They called them the guardians of the Constitution. And so these guardians would have life tenure if they had good behavior. So life tenure with good behavior. And they could only be removed if they were impeached. Now, let me just tell you why I think life tenure, from my anecdotal perspective, is a good thing. And it's all tied to some of what the dean has said to you. Part of why I believe so is based on my growing up in the South and seeing the very difficult issues that judges had to wrestle with. And it was hard enough when you have life tenure to extract yourself from the community and to decide issues based on the constitutional principles. It's almost impossible if you have to go to the electorate to do that. Now, I grew up in Bessemer, Alabama, as the dean said, one of 10 children. 1963 was the year that Martin Luther King was jailed, and there was a letter from the Birmingham jail. The same year the girls were bombed in the church there at 16th Street Baptist Church. It was the same year that George Wallace stood in the door and tried to block two blacks who were coming there. And the Justice Department had to nationalize the guard and allow those students to enter. That's 1963. So I was in 10th, 11th grade. 1965, the Selma to Montgomery March. We've been watching Selma, some of us, recently in the movies. That was my high school senior year. You saw how bloody that situation was. You saw how the lawyers had to go into court to get an injunction. And you saw a little bit about how legal relief was obtained in that case. There are judges in that context who stood up over the years. There were not that many, but who were able to live in the South in the context of facing strong opposition, threats, including death threats, and they were still able to move forward. And one of those was Frank Johnson. I don't know if you've heard of Frank Johnson, but he was a district judge out of Montgomery, Alabama. And eventually was on the 11th Circuit Court of Appeals. His father was one of the few Republicans who served in the Alabama state legislature. He received his law degree from the University of Alabama, served in the war, returned to practice there. He was appointed by President Eisenhower as U.S. Attorney, and then as district judge, he was 37 years old. He turned out to be a staunch defender of Brown versus Board of Education. He was part of a majority in the three-court panel in Browder versus Gale, which ruled in regard to the Montgomery bus boycott led by Dr. Martin Luther King Jr., and which Rosa Parks was the heroine. And so he was the judge in that case. But he also ruled that Brown versus Board of Education did not just apply to public schools, but also to public transportation. And he would go on to rule and issue decisions, important ones, in regard to the segregation in the 50s and 60s in regard to parks, libraries, and airports. And he had to have continuous protection by the U.S. Marshals for more than 17 years. He and his family faced death threats, cross burnings on their lawn, and one bomb targeted his mother's home. And in the 1970s, he continued to make decisions of great social and societal impact, reaching decisions in Wyatt versus Stickney in 1971, Newman versus Alabama in 1972, and Pugh versus Locke in 1976, requiring more humane conditions for mental hospitals and in prisons. When he got appointed to the 11th Circuit in 1979 by President Carter, he wrote the opinion for the court in Hartley versus Bowers, declaring Georgia's sodomy statute unconstitutional when applied to consenting adults. And he was reversed. He lost in that case because he had ruled opposite of the Supreme Court. But later on, he was vindicated when the Supreme Court reversed itself in Lawrence versus Texas. So that was Frank Johnson, sitting in Montgomery, Alabama, with courage and conviction. He was a federal judge. If he had been elected judge, elected by his peers in the state, by the voters, absolutely no way that he would have been able to do what he did. Now, the question is, would he have had the courage without being having life tenure? I don't know. I'd like to think that he would have. But if he had had the courage to do what he did, he would not have remained in office. That's an important point. There were others in the South, and I'll be quick in regard to these, but you ought to know some of these names. Skelly Wright. Skelly Wright was from New Orleans. He was a nominal Democrat, and he was the person who concluded that segregation in New Orleans schools clearly violated Brown versus Board of Education. And the state would come back with, the school system would come back with one more way to get around the decision, and one more way to get around the decision, and one more way to get around the decision. But he persevered and eventually was appointed to the Fifth Circuit. But it's important to understand Skelly Wright, John Minor Wisdom, and Judge Tuttle of the Fifth Circuit are names of judges who were in the thicket in the South, and yet were able to stand up and to rule favorably in regard to the segregation cases. Now, let me just say that Judge Skelly Wright was called Judas Scalawag Wright. He was called Judge Smelly Wright. He was hung in effigy. He received obscene phone calls, and he was the victim of cross burnings at his home. He has been described as a virtual pariah in his own state, compelled to rely on armed federal marshals to escort him to and from his office and to guard his home. President Kennedy considered appointing him to the Fifth Circuit, but he concluded that he could not. He would not get the support from Southern senators. So what he did was he appointed him to a vacancy on the D.C. Court of Appeals. Now, Judge Johnson brings to mind the current federal judge, the Southern District of Alabama at Mobile. And that judge is Judge Callie, and I'm not sure you pronounce her name, Grenade is the way I've been pronouncing it. But she's the judge who recently struck down Alabama's constitutional statutory ban on gay marriage. Now, Alabama has a constitutional amendment that was approved by 81% of voters in 2006. And it's interesting to watch this former U.S. attorney who worked on the Senator Jeff Sessions when he was the U.S. attorney, and she succeeded him. And a woman who talked in such conservative tones when she was before the Senate. And yet, when she was clothed with the robe of a judge and given life tenure, she decided the Constitution required her to strike down Alabama's constitutional provision. Now, I'm not saying whether she was right or whether she was wrong. I'm not venturing an opinion. But judges have to have some courage. They have to have some courage to follow their convictions. And so it's important to watch that case. If you followed the case, you've seen that the Supreme Court Justice of Alabama, a guy named Roy Moore, who's quite a character. So he had 10 commandments in the courthouse there before when he was Chief Justice, and he would not remove it, despite the fact that there was a federal order to do so. And so he was eventually turned out of office by a special court commission to look into his conduct, and he was thrown out. But he became popular. He ran for governor. He didn't win, but eventually he ran for office again, and he's back on the Supreme Court. And he has been ordering those probate officers across the state of Alabama not to comply with the judge's decree. And I understand some of the arguments, we won't get into those, but you can see right now that there's a showdown in Alabama in regard to whether and how their orders will be enforced. But she obviously is being vilified in her hometown, in her home state. 81% of the voters passed the constitutional amendment, which she struck down. Would she have done so if she was elected? And if she did so, would she be there to render the next decision? Those are questions we have to ask ourselves. Now, let me just give you another modern example. I'll say a little bit about my own case, and then I'll talk to you not just the case for life tenure, but how do we work to ensure that it's not abused? Because I think that's important if we're going to have life tenure. So back in 1996, the judge who came on the court, really close to the time I came on the court, Judge Harold Baer, Southern District of New York, he rendered a decision that said that police officers lacked an adequate basis to pull over a car in the Washington Heights section of Manhattan. And therefore, the 80 pounds of cocaine and heroin could not be used as evidence. And you could imagine the outcry. Senator Dole was running for office, and he suggested that he should be impeached. Even President Clinton's spokesperson kind of suggested they might ask him to resign. And there were many others who suggested that he resign. Now, I don't know that Judge Baer changed his opinion because of the outcry, but he did reconsider his opinion, and he decided that, in hindsight, that he should have not granted the motion to suppress. I cite Judge Baer just to suggest that we have very difficult decisions to make as federal judges. That much drugs, some people would look at that and they would say, that much in the way of drugs, and he's suggesting they think on a technicality or however they view it, that he would prevent them from using that evidence. Those kinds of decisions we have to have the courage to make. We don't have to make those decisions every day. We're not suggesting that every time police officers come into court that they'll be found to violate the law. Far from it. But when I feel that that is the case, if it's 100 or 1,000 pounds, I should have the courage to make that decision, understanding the meaning of that decision in the context of our law. Now, let me just say a little bit about, I'm not going to say much in regard to my own cases, and I'll have to be careful when you do that. But I had a school voucher case, which I talked to some of you about over the last few days. And it wasn't as hot as some of these cases, especially in Cleveland, but it was more nationally hot. And I received a lot of letters, there were a lot of editorials in regard to that case. And briefly, what it entailed was the state of Ohio decided that it would help Cleveland schools because they were viewed as being in dire straits and not being very good. And so they said, we'll give money for a certain number of students to go to other schools in the area. They could be public schools or they could be private schools, if they sign up. No public schools sign up, only private schools signed up, and most were parochial schools and most were Catholic schools. And so the question I was facing was whether or not the use of the vouchers in that context violated the Establishment Clause of the United States. And the reason I concluded that it did was I concluded that when one wanted to avail him or herself of a voucher, that one had to take to the religious indoctrination with it. There wasn't much of a chance to get the voucher without the indoctrination. There was nothing wrong, I felt, and I was sure, with having parochial schools part of the program. But if in fact there was no choice for the parent and student but to take the religious indoctrination, then it would be a violation of the Establishment Clause. Now, I'm not getting into a lesser constitutional law in regard to this. Sixth Circuit affirmed me. The Supreme Court had the last word, and they were 5-4, and they said that the case should be reversed. But during that process, I saw how not only the newspapers but other people who saw the case were very emotional. And I told the students the other day that I was reading the paper, and it was like I was described as putting the coal in the stocking of the students in Cleveland just before Christmas. One guy sent me a check for $10, and he said he would like me to use that to start my retirement fund. Now that kind of humor I can take. I don't need marshals to protect me from that. There was another guy I told them yesterday who said to me, I will come clean in regard to my background, and I don't remember all he said, but he says, my parents came here from Italy and so forth, and he went on, and he says, and I'm trying to figure out what your background is, but I think I can figure it out based on this decision, that you are either African American or homosexual. And so that's the kind of thoughtless responses that you sometimes get. And some accuse me of being anti-religious. They did not know that my father was a minister, that I have attended church all my life, that I still do so. They knew nothing about me, but the idea is that if I would strike down something that would cause these students not to go to these religious institutions, then I must be anti-Christ. It was interesting time. I had to make another decision. It's not so much about my getting threats either, but let me give you a sense of what kind of difficult case I had. Case is on appeal. I will not talk about the merits. House burned down, 8 little kids and an adult. They can't find out who did it. They spend years doing it. FBI finally gets involved. They filed an indictment, and it's based on the fact that the house, the rent in the house is paid under Section 8 of the HUD statute, and so therefore, and I thought that wouldn't be a basis for that kind of case, but it was apparently sufficient. Then the government asked for a death specification, that the guy be considered for the death penalty. I had a rule in the first instance whether he had a mental disability, and we went through a long process to determine that. And I determined that he had a mental disability. That took the death penalty specification away. Tried the case. I decided that the case should be overturned and be retried. I just found that the evidence on the first trial of the case was so insubstantial relative to the overall evidence that it should be retried. Very rare kind of thing to do. I acknowledge it was very rare, but determined that I had to do that. Sixth Circuit affirmed me. The case has been now retried and on appeal in the Sixth Circuit. Those are tough cases where people in the community may see a judge as soft. A judge is siding with a criminal. A judge who's standing in the way of solving major crimes where people have died. And the emotion was in the courtroom, on both sides of the courtroom. It's a heavily fought case. And outside the courtroom, people essentially get into skirmishes and fights. That's the kind of decision that I wouldn't want to run on in Cleveland, Ohio, or any other place where you're talking about the fact that people have died And that's what people are focused on. And so that experience of mine and the others that I have not talked about, and the judges I have talked about and their experience in the South, courageous judges, suggests to me that as we move from now through history and have other hot button issues, because there always will be over time, that we must have people, at least in our federal system, who can stand back, take the heat, worry, cry, do whatever you got to do, but come to the right decision without regard to whether people are going to elect them or not elect them. Now, how do you, if you take my view, and I know people don't because they think, some people don't because they think there's a lot of abuse, and I don't think it's a perfect system myself. I think it can be criticized. What is there to at least help guard against the main problems that one can encounter as a result of life tenure? I think it's the same kind of thing that people worry about in terms of professors in the university. The idea is that tenure is viewed as a good thing, but I think all of us sometimes feel, time to time, it doesn't always work out exactly right. So what can you do? In order to avoid really this notion of arrogance, of being insular and unaccountable, I think that we have to consider the fact that we have a very rigorous process for nominating people federal judgeships. First of all, you can't do it at 30 or 31 like you can do if you want to run for state office. Not that we have that many people, but most people who become federal judges are about 45 or 60, 45 or 50 or so. And so they already have a track record. They already are seasoned. They have to get through either a Blue Ribbon Committee or through senator's staff, and they have to get ultimately through the president. And so I think that there's a lot of scrutiny that goes on. Many of you don't know that you have to fill out a form for consideration, and it's a Senate form. And I don't know how many pages it is, but it is a lot of pages. And you have to cover every place you've ever been in your life, everything you've ever done. And if you can get through that process, it suggests, at least on paper, that you are pretty clean in regard to certain things. But also, any writings you had, any other things that you've said are subject to scrutiny. And so I think that that is one thing that will give us some comfort. Also, there's an ABA standing committee, and I don't always agree with them, and they have sometimes made decisions that I would certainly not support. But as a process, they're looking at every candidate, and they are making a recommendation as to whether they're qualified or not. And then you've got to get through the Senate process, which has become more difficult than it should be in recent years, but that is some solace as well. So, rigorous process for obtaining position. We have a substantial program for educational, for education and renewal. We have a federal judicial center that's really top-notch. We have workshops that happen all the time, which all judges are invited and most attend. We have all kinds of pamphlets and treatises and information that are given to us on almost every subject. And so there is a great effort to make sure that we are up to speed and that we are renewed. Now, we have a program to review and receive complaints and to impose discipline. Been some criticism of whether that system does as much as it should, but there is such a system in every circuit. You can file a complaint, it can be reviewed, a committee can hear it, and a party can be disciplined. And so we have that. Let me just say quickly that in addition to the canons, we have a statute which deals with judicial conduct and disability. And that is a statute by which we can determine that a judge is disabled or a judge has not engaged in proper conduct or conduct prejudicial to the effective and expeditious administration of justice. Now, that statute was challenged because there was a Texas judge 2 years ago who was disciplined because he was mean, he was rude, he was really just a bad actor in terms of lawyers and judges. His name was McBride. He's from Fort Worth. And he went all the way up to the Supreme Court because he was challenging the fact that the Judicial Council of his circuit imposed a ban on his receiving any new cases for a year. His argument was this violates my rights as a judge, but also interferes with Congress's right to impeach, and that this interferes with life. In fact, his life tenure was taken away for a year. The Supreme Court refused to hear the appeal from that, and so that statute is a viable statute for judicial councils to take action against judges. Let me conclude by saying that I was, as I told you, I was biased up front. That this was not a scholarly dissertation, but I wanted to share really some of my thoughts, impressions with you about life tenure of federal judges. I do think that life tenure is critical. I'm not suggesting it could not be done any other way. I think for the most part, it has worked well. I think it has allowed judges of courage to render decisions that would have been very difficult to render in a context where they would have to be elected. And I'm forever marveling at people like Judge Frank Johnson, people like Skelly Wright, people like Waits Waring, a judge out of South Carolina, who early on sustained so many challenges to so many segregated facilities in South Carolina. These were people who had marshals outside of their homes, and they had to live in that context, and yet they were able to stand. I feel proud to be a federal judge with the responsibility of making hard decisions. I'm willing to agonize and do whatever I can, and sometimes I'm sure I make decisions that people wonder, how could he do that? Why did he do that? I think at that time it's just important to have some faith overall, not in me, but in the institution, how it's designed, what it's supposed to do, and take some solace in the fact that overall it has worked well. So thank you very much, and if you have any questions before you go to class, I'll be happy to receive them. I know most of you have class, and I don't think there's much time left. I think I used up most of it. But if you have any questions, I've talked to a lot of you, and I've answered a lot of your questions as I've gone. But if anybody has a question I'd like to answer. Yes?
What's your point of view on retention elections where judges are appointed and then have retention elections after so many years?
So they come in a couple of different varieties. But so just to retain them, they're running against themselves essentially. Is that it?
Yes. And
they have maybe a 14-year term or something like that. I guess it's better. I'm not saying that every state should have life tenure. I think it's a lot better than being elected every 6 years, and you got to have an opponent. So a retention election, to me, comes closer to protecting the ability of a judge to be fair and impartial. Of course, it depends on what decision you render, how close that is to your election. But it's a lot better system, I think. Some variation on that. But when you have that kind of system, you've got to start to do something like they do in the federal system. You've got to have either some kind of blue ribbon committee, nonpartisan, that will come up with a variety of names, and then have that be done in a way which doesn't sound so political. There's always politics involved to some extent it's little p and big P. But I think if you're going to have a system where the person doesn't have to run against someone, and then I think you got to do that. Otherwise, I think the better argument is just to let everybody have a chance. So I would prefer that system, given the fact that that would be something on front that would require quality and some assessment. Yeah.
In states that do elect their judges, how do you feel about the tension between freedom of speech and the role of the judge as one who's supposed to remain impartial or sort of disinterested to a certain extent?
I think that's another problem. I mean, you're running, but you can't talk, and you probably don't want to talk, but you're bound by the canons not to talk about certain things, and so you just it's kind of a little dance. I mean, you really can't talk about your cases. You can't talk about what you would do as a judge. That's one of the things you can't do, and so that's why it's so awkward to be out with the governors and the mayors and people when you just don't fit within that framework. I understand all the arguments about accountability. It's just that I don't think they apply in the same way that they apply in regard to elective office. Yes.
I was talking to a judge who was elected, and I happen to agree with you that I think I lean towards thinking that appointed judges and lifetime appointments are best. But she raised the point that elected judges, the provision of elections for judges means that there could be more diversity on the bench. What do you think of that?
She thinks of elections?
Yes.
Well, I think that's entirely depends on the area in which you live. But let me say overall that the federal courts have done pretty well in terms of percentages relative to the states. And I don't know the numbers now, but I think, for example, I mean, I don't have the numbers for Hispanic and Asian American and final numbers for black, but I think it's probably about 10% or more. That's not better than the profession in terms of lawyers in the profession. It's been uneven. So most of the minority judges that are on the court were appointed by President Carter, who's the first one that ever appointed these significant numbers, President Clinton, and now as he finally got off the ground and was able to move more, President Obama. So the numbers are pretty good, but they don't happen in a consistent basis. When I was appointed as a district judge here within the Sixth Circuit, I was the first judge within the Sixth Circuit, Court of Appeals judge or district judge, appointed in 12 years. Now, shortly thereafter, President Clinton appointed others, so there were quite a number. But that's kind of how it goes. But it's better in the federal system overall than it is in most states. But now it depends on the state, and it depends on the area. If you're from a geographical area that has a substantial minority population, and the minority population is responsible in terms of voting, getting out and voting in appropriate numbers, then that would be different. Yeah.
Well, thank you very, very much for a wonderful talk. Had a chance to meet the judge, I encourage you to take some time between now and the end of the week to at least say hello and have a conversation that's going to surprise you, okay? Thanks so much, everybody. Good job. Thank you.